Ready? All right, guys, so we're going to start on chapter 1 tonight, which is on page 5. One of the things I'm going to tell you, one of the things I'm going to tell you is that we're going to cover the first 6 chapters kind of quickly. Hey, come on in.
Come on in. Let me go down and get some books.
Okay, well, I've got one right here.
Okay. And I got another one downstairs. I'll be right back.
All right, so the deal is this. If it's in the book, it's subject to being tested. So in between the covers, it's on the test. And the reason we cover the first 6 chapters tonight is because what we have found is that historically, the first 6 chapters are not highly tested. That doesn't mean that something in here won't be on the test. It just means that we're not going to dedicate 3 nights to covering the first 6 chapters. And so on page 5, that second paragraph says, in most civil law jurisdictions, the functions of the notary share the following common elements. Notaries are lawyers who perform quasi-public functions, and they are required to go through rigorous professional training before they are allowed to practice. B, in accordance with the intentions expressed by their clients, notaries confer authenticity to the declarations made by the parties to a particular legal transaction. C, notaries provide their deeds or instruments with a fixed date and keep the originals of the deeds or instruments prepared by them in their custody. And D, notaries are charged with determining the marketability of title to land. So how are we doing so far? Does that sound about right? Does that sound about right? No? Yes? As notaries, we provide quasi-public functions, and they're required to go through rigorous professional training and have to be attorneys? Yes?
They don't have to be.
They haven't got to be an attorney?
Oh,
No. B, in accordance with the intentions expressed by their clients, notaries confer authenticity to the declarations made by the parties to a particular legal transaction. How about that one?
I'm sorry, you went too fast.
B, it's right there on page 5. In accordance with the intentions expressed by their clients, notaries confer authenticity to the declarations made by the parties to a particular legal transaction. How about that one? You think you'll be doing that?
Yes.
Yes. Notaries provide their deeds or instruments with a fixed date and keep the originals of the deeds or instruments prepared by them in their custody. Will you be doing that?
Yeah. No.
Not really. You're not going to be keeping them in your custody. A lot of the documentation you're going to generate and you're going to notarize will end up at the clerk of court's office in the public records. We have a public record system in Louisiana. But not all notarial jurisdictions, not all civil notarial jurisdictions have that mechanism. We did a succession for a lady who had a piece of property in Lakeview. Does everybody know what a succession is when I say a succession? Yeah? All right, so a succession is when you pass away and you've got to probate their estate to get the decedent's property into the hands of their heirs or their legatees. And so the woman died with a piece of property in Lakeview, but she was actually a resident. I don't remember the Latin American country she was from, but her will was in the possession of her notary in this country. And we had to get that will in order to probate her succession so that she was in Guatemala?
Yes.
We had to probate her Guatemalan testament in order to be able to sell her house in Lakeview. You had a question, Lisa?
I do. CDC notaries in Orleans have to keep theirs, don't they? Or they have to keep record of it? Not differently.
No? What do you mean? What do you...
They have to, Orleans Parish.
Okay.
notaries, They have to keep
An archive.
an archive, yeah. That we don't have to in other parishes.
They actually stopped.
Did they?
Yeah, they don't do it like that anymore.
All right.
But they used to, you're right.
Because every time I call them, if I have the notary's name, they can find them.
They might just keep their own record.
Yeah, I think it's
Well,
68,
it
68 and back, or 70 and back. They
Is it that far
had, each
back?
notary had a book for themselves.
That's old school, man. 68 and 70? That's a long time
And
ago.
it went to the
You don't
archive.
record your transaction?
What's that?
You don't record?
Yes.
Your suit?
Yeah, but C says you're going to keep the originals. C
Okay.
says notaries provide their deeds or instruments with a fixed date and keep the originals of the deeds or instruments prepared by them in their custody. And that's what we found. This Guatemalan notary did not want to relinquish the testament because it was his document and it was going to always stay in his records. And so we struggled, besides just the traditional language barrier you would have talking to an attorney or to a notary in Guatemala, we struggled with this concept that he would not part with the original. It was not something that we had ever dealt with before. And so, more importantly, it wasn't in English. More importantly, that last will and testament was in Spanish. So what we ultimately had to get from him was we had to get a translated copy of the testament certified as being a true copy of the last will and testament. That was all he was willing to part with. And we were nervous. We were concerned that when we probated that testament at the CDC, because this was in Orleans Parish, that the judge would kick it back because it wasn't the original testament. It really wasn't even anything that had been signed by the decedent. It was a translated version of the original that was going to always be in the records of this notary's office in Guatemala. But the judge signed it. Apparently that wasn't the first time he or she had seen something like that. That was the only way it could be done. So, not in our jurisdiction. Notaries in Louisiana rarely, if ever, keep their originals. And if you do keep your originals, let's say you generate a document for someone and it's a document that does not have to be recorded. Let's say it's a power of attorney. But at some point in time when that power of attorney has to be utilized for a transaction, there's going to be an expectation that you in your capacity as a notary are going to relinquish that document to the client so they can deliver it to the Office of Motor Vehicles, or they can deliver it to whoever is expecting it and relying upon it as a basis for letting someone else act in that person's capacity. Does that make sense? Yeah? Okay. All right, number D, or letter D. Notaries are charged with determining the marketability of title to land. What do y'all think about that? Is that something you're going to be doing in your capacity as a notary? You're going to be a conveyancer, but you won't be determining marketability. There's a footnote, number 4 footnote at the very bottom. It says in Louisiana, marketability determination is accomplished by procuring for the parties a title opinion from a licensed attorney. We're going to talk more about the difference between determining marketability and conveying property. There's a distinction between the two. Notaries in Louisiana do not do marketability analysis unless they're attorneys as well, and they're able to render legal opinions. It says in many civil law jurisdictions, only authentic acts may be inscribed in the public records. Thus, the mechanics of the registry system rest upon the notarial profession. But what's an authentic act? Who can tell me what an authentic act is? Like, I know you know what an authentic act. What's an authentic act?
It's where you actually sign it as a wedding signature on it and it's certified by a notary.
And you have 2 witnesses. So an authentic act is going to be an instrument that's executed just as he said. You said wet signature. It's going to be an actual signature before a notary and 2 witnesses. And that's a form that you're going to become very accustomed to. And there's going to be a whole list of different instruments towards the back of the book. Things that must be an authentic act to be valid, and things that don't have to be an authentic act to be valid. But let me tell you what we do as notaries, as we have a tendency to overform. Because some things are not valid unless they're in the form of an authentic act, we have a tendency as notaries to draft everything as authentic acts just to be on the safe side. Okay? So we'll talk more about that. But an authentic act is an act passed before a notary and 2 witnesses. Can the notary be the witness as well?
That's not a good.
It's not. No, they can't. They cannot. The funny thing is that in some jurisdictions, a notary can be perceived to wear 2 hats in any given transaction. And if you send something out of state to be notarized, you got to pay very close attention if you didn't give them explicit instructions on how to execute it, that the notary did not also sign as a witness. Because if the notary acted as a notary and acted as a witness, because maybe in Oklahoma they do distinguish the 2, and that document comes back and that notary is also the witness, you don't have an authentic act because you've got a document that's executed before a notary and 1 witness, and it won't be valid in that way. All right, so the concept of the notary as a public official on page 6, it says the law of 25 Vintage year 11-1803 defined French notaries as officers public in the charge of receiving all acts required to be executed in authentic form. And if you were here on Tuesday, we talked about how in many states notaries don't have to meet any certain criteria. Notaries simply have to have an insurance policy in place, they have to pay a fee to the state, and they have to have a stamp that they can get from Office Depot, and with that they're able to notarize documents. Consequently, what they're saying in the book, middle of that paragraph, it says, if you were to say notary is a public official to a common law attorney or a person that's well-versed in common law language, they're going to find that public official comment kind of odd because there's no real authority for which notaries in common law states exist. They exist simply because they paid their fee, they probably have a clean criminal background check, and they got their stamp. They have their insurance policy. So this public concept, the public concept kind of stems from this, and this is in the middle of that paragraph under the concept of notary public. It says a notary is a member of the legal profession vested by the state with public authority and faith. Vested by the state. Who vests you in your capacity as a notary? Who vests you with that authority? Secretary of State? Yeah, and in some ways the governor as well. But yes, that's where our authority as notaries is coming from. As a matter of public policy, the executive power imposes on him the duty to provide the proper form, authenticity, and how do you pronounce that? Solemnity? All right. For the facts, transactions, and documents of all interested parties, and give them absolute assurance that what has been done for them has been done in accordance with the law. Okay? The term public official, as applies to a notary, is used in a vague sense and may create some confusion for the common law attorney. The office of the notary is an independent of any branch of the government and is unrelated to functions which are handled by the public bureaucracy. Let me read that again because that's important. Your office of the notary is independent of any branch of the government and is unrelated to functions which are handled by the public bureaucracy. So if someone walks into your office, Ms. Jackson, and they have a complicated transaction, what they're saying is, don't ring the Secretary of State asking them to help you through it. They may vest you with the authority, but they don't regulate how you manage your office. That's what they're saying. Does that make sense? Okay. The notary's status as a public official flows from his license to practice as a notary, which is conferred by an organ of the state. The public character of the notarial function is reinforced by strict administrative standards for keeping the original acts passed in his presence and by the quasi-monopolistic power to authenticate documents. All right, well, we talked about how you won't always keep your documents in your custody. There will be many occasions in which you'll either release the originals to your clients or you will record the originals with the clerk of court. What does quasi-monopolistic mean? I had to look it up. It just means like a monopoly. I don't know why they just didn't say that. That would have been easier. All right, the next paragraph on the bottom of page 6, it says, as an independent professional, the notary is free to organize his office and administer his services as he sees fit, and he bears complete and exclusive responsibility for the manner in which his services are performed. In a few civil law jurisdictions, however, the notary is under an obligation to avail every member of the public of his services unless special impediments excuse him from intervening in a particular transaction. Do you have to help everybody, guys? Is Louisiana one of those jurisdictions? By show of hands, do you have to help everybody?
No.
Doug, you say yes?
I'm going to say
He
yes.
said how?
You don't have to help everybody. You don't, but I appreciate you throwing your hand out
I
there
know
and giving it a shot. You don't have to help everybody. As a matter of fact, we're going to talk an awful lot about why you shouldn't do some transactions. Not everything that gets presented to you should be notarized. You should not be a person that prepares everything that you're asked to prepare. There's a very, very fine line. You do not have an obligation to help everyone that comes into your office. Sometimes no is the right answer. The notary is not paid by the state but by his clients, and the notarial fees are considerably higher than those charged by his Anglo-American counterpart. So the civil law notary may get a little bit more money for their notarial seal, even if all they're doing is verifying your ID. They may get a little bit more money because of what you've got to go through to be able to provide that service in this state. Whereas the person who simply has the insurance policy, paid the fee of the state, and got their seal from Office Depot, they may not be able to expect a comparable fee for their services. One, they can't do nearly as much for their clients as you're going to be able to do in your capacity as a civilian notary. And two, they didn't have to work very hard to get to that point to be able to provide that service. Okay? What you charge? Is there any kind of cap? You know how they had that price gouging after Hurricane Katrina? Is there any kind of cap on what you can charge for your services? Ms. Jackson says no. I like that answer. There's no cap. Obviously, you can't charge too much. You price yourself out the marketplace. Okay? So if you walk in, you want me to notarize your power of attorney and say it's going to be $1,000. Well, obviously, you're going to turn around, you're going to walk right out and go find somebody else. But if I want to charge you $20 for that, or $50 for that, I've got the discretion to set my fees at whatever I feel is appropriate. I had a young lady walk into my office one day, a particularly good day. She walked into my office and she said, hey, are there any notaries here? I said, well, you talking to one? And she says, I got to get this document notarized. Can you help me? I said, absolutely. You have your driver's license with you? She says, I sure do. She says, before you help me, how much? And I said, $20. And she goes, oh, I don't have $20. And then I said, well, I'll do it for $10. And she said, I don't have $10. I said, well, how much do you have? She goes, I actually have no money. And I said, well, today's your lucky day. And I notarized that document for free for her. You don't have to charge everyone that comes to you. As a matter of fact, the moment your friends find out you're a notary, that's exactly what they're going to expect, is that you're not going to charge them for your services. All right. The second paragraph on page 7, guys, the second paragraph starts with the number of notaries is fixed by law. There's a footnote. At the bottom of the footnote, it says, in Louisiana, the number of notaries is no longer fixed by law. The governor has the power to declare a moratorium on notarial appointments. That's never happened that I'm aware of. Has it ever happened that you're aware of?
Well, I think they're doing that anyway.
Well, they may be attempting to regulate the number of notaries by establishing higher standards to qualify.
Yes.
But the governor has never actually said no more notaries. And so there is no fixed number of notaries. There is the ability for the governor to establish that they're not going to create any more people in that capacity, but never, in my knowledge, has the governor of the state of Louisiana ever exacted that authority. Okay?
What are the, what's the criteria now?
What do you mean?
To become a notary.
Well, what are they trying to raise? What specifically are they adding?
Well, what they're doing is they're trying to establish the minimum standards for a notary by creating what's known to be a very difficult test. The
Okay,
test that you've got to pass at the end is very, very tough, and the idea behind it is that if you pass this test, then you should be a good notary. And if you don't pass the test, then you need to work a little bit harder to come back and pass the test. So it's not a standard that you have some discretion in meeting. You pass the test, you're good to go. Okay? All right, it says in that same sentence, the number of notaries is fixed by law, and the power conferred upon a notary to execute authentic acts is limited to the district for which he was appointed. What district will you be appointed in, Michelle?
Louisiana.
Louisiana? You had a different answer? No? Why not St. Tammany Parish? You going to say St. Tammany Parish, Brian?
Now, wasn't it like numbered? Wasn't it like first, or wasn't it broken down to numbers? Somewhere later
It's
on.
where
in the
you
chapter.
live at.
The parish where you live in?
Well,
I
for,
think it's 3
well,
parishes.
for the, what are you talking about, for like the courts?
Well, where's your notarial authority going to come from? I mean, where will you be able to execute documents? We've
Oh,
got-
anywhere in Louisiana.
Anywhere in the state?
No,
Anywhere
you
in
could
the,
do other states if you have it,
you can do other states?
no, you can, not other states, but what is that 4-part something where if you have to, from another, with something like that.
I trust you at some point, but I don't know what to say though.
I saw
So-
something where.
I mean, not-
Like as long as it's done here? If you're done, you can authenticate an act outside, for someone outside of the area.
Right.
As long as you do it
It
in
has to be
your
in
parish.
your
And it has to be approved by the 4, it's somewhere in this book.
Well,
Right,
if it's somewhere in the book, then we're going to probably come across it. So here's the deal. As a notary in the state of Louisiana who passes the statewide test, you will be able to execute documents in any parish in the state. So that is the answer. There are many, many notaries who qualified to be a notary at a time when we did not have a statewide examination. And their authority is going to be limited to the parish in which their commission was earned. There's a young lady who works in my office, a super smart lady, could easily be a notary anywhere in the state, but she got a notarial license so long ago that she's only a notary in St. Tammany Parish. Doesn't have a need to venture outside of St. Tammany. Consequently, she's never taken the statewide exam. So you're going to come across people. They're going to tell you, no, I can't drive to Tangipahoa and help you with that because I'm only licensed to practice in St. Tammany. And you're going to wonder, well, how are you only licensed in St. Tammany? Well, it's because he or she got their notarial license 15 years ago. Was it 96?
2005.
2005, that's when the statewide exam went into effect. So anyone who's taken and passed the statewide exam after 2005, those people have jurisdiction across the state. Why do you think that the Secretary of State took over the notarial responsibilities? Any thoughts? This really is in the book. Any thoughts? No?
So they all go together at one place?
Some consistency in the quality of the notaries that are being produced.
It was
this-
different. Each
yes.
parish had different teachers, different things to qualify, to determine who would give the test. St. Tammany Parish may have been, this particular attorney that's doing it here. And like up north, Louisiana, where they want to like education is not the best thing. But in the past, their test is it's not compared to the one that may be in St. Tammany.
You hit on a very hot button topic right there, which is a distinction between the number of people that pass the statewide notarial exam when you consider North Louisiana versus South Louisiana. That's actually a very, very big problem. The clerk of court of the parish in which you were domiciled was the person responsible for issuing the commissions. There was a lack of consistency between the parishes as to the knowledge you had to be a notary. We were churning out notaries in various parishes with varying degrees of qualifications to do it. And, I'm not picking on anybody. but the notaries in the northern part of the state were not being held to the same standard that the notaries in the southern part of the state were being held to. Consequently, when you look at the pass rate across the state, northern Louisiana notaries do not pass at the rate that southern Louisiana notaries pass at. You said that the education may not be as important. May be very much as important, it just may not be as consistent in North Louisiana as in Southern Louisiana. So the state took it over for the purposes of establishing the consistency of the information for which you had to demonstrate a proficiency in to become a notary in the state. That was the reason the state took it over.
My cousin has a notary license prior to 2005.
Mhm.
He has it for 3 parishes.
Yep.
St. Helena, Tangipahoa, Hole, and I want to say Livingston.
If we get far enough, we're actually going to talk about how there are some parishes that have reciprocity, where if you're qualified to be in one parish as a parish-wide notary, you automatically get the other one as well. There's a dual commission where you live in one parish but you work in another. There's all kinds of things that would allow you to be in one parish but have authority in a couple. Now, I'm a Louisiana notary, and as a Louisiana notary, I am often asked, well, can you help me with these Mississippi transactions? And Simone kind of touched on this, and the answer is, I don't know, do I have to come to you or are you coming to me? Because if you want to bring a Mississippi transaction in Louisiana, I'm your guy. But the moment I cross state lines, my superpowers go away. I'm no longer a notary in the state of Mississippi. I can't notarize anything, which is kind of difficult because we're so close. There's an expectation that your client, that you're my attorney or you're my notary, you're going to follow me to Pearl River County or Hancock County and help me out with the transaction, and I do. I will follow my clients anywhere they need me to go. But I'm going to make arrangements for a Mississippi notary to be there to serve in the capacity that I can't serve. I can disclose the documents to you. I can tell you what we're doing, but I'm not going to be able to actually seal anything for you because I'm not licensed or am I authorized to be a notary in the state of Mississippi. Okay? All right. The function of the notary is a multi-party counselor. The role of the notary is not confined to preparing and authenticating statements or declarations made by his client. He is also the legal advisor of the parties, acting as a mediator who seeks to harmonize opposing interests. What do you think about that? You ever given some legal advice? No. I hope not. The footnote says the notary in Louisiana who is not licensed to practice law may not give legal advice per se, but is authorized under the statute to find the practice law to perform any act necessary or incidental to the exercise of the powers and functions of the office of the notary public. What do y'all think about that? You're going to be able to do that, Michelle? When somebody comes to you and they want you to help them with a will and they ask you a question that might kind of be on the verge of maybe being legal advice, you're going to be able to say, no, you need to go talk to an attorney and then come back and see me? You're going to be able to do that? It's tough. It's really, really tough. The line between being a notary and providing notarial services and offering legal advice, you put your toes right up on it. It's not very, so this is an example. It's a slippery slope. Thank you. What's that?
So I'm gonna stick to my specialty. If I wanted to be a lawyer, I'd have gone and been a lawyer.
So I come to you and I say, Michelle, I have a wife and I've got some children, and upon my passing, I want my wife to have usufruct over all my stuff for the rest of her life. I don't want to end when she remarries. What do you think about that? And then you can say, well, I think that's a good idea. That could potentially be legal advice. Somebody might construe that as legal advice.
Documents, but go get some advice.
Exactly. So,
and bring it back to me to notarize.
well, what's the likelihood they're going to come back to you when they go to see that attorney and they say, well, listen, Michelle's my notary and she's going to prepare this testament, but she wants me to come ask you this question. You think that that attorney's going to snake your business at that point?
That's what I'm getting good with the attorney.
Oh, okay.
You got a network.
All right. So that's there. I'll come to you, Simone. So that's maybe a good way to approach it. My point being, and you actually said it better than I could, it's a slippery slope. There are times that people are going to ask you some very basic questions, and the answers of which could be construed as legal advice. And I don't envy the situation you're going to find yourself in having to address those questions. It's not going to be easy. Let's hear it.
We'll just send them to you when you know that you can send them back to us.
Kim, I appreciate that. I appreciate that vote of confidence. What's your question, Simone?
So if someone comes in with that scenario, they say, this is what I want to do, then you maybe could say, okay, have you considered that, and is that what you decided you want to do? And then from that point, then you just do what they've asked you.
Well, I'll tell you, this is probably the way that you will handle it in your capacities. You're going to say, hey, I'm a notary, I'm not an attorney. So this isn't legal advice, but I think that's a great idea if you want to handle it that way. Yeah. You know,
If it was me.
if it was me. So there are going to be ways you're going to be able to kind of hedge that advice to where you feel like you're giving it, or you're at least giving them the value of your opinion and not necessarily crossing that line. You know, it's tough. Like I said, it is tough. And just in terms of the context of doing wills for people, lots of legal questions can come up. Hey, what's the age for forced heirship in Louisiana? You know? And the answer is, Will 24 with a varying degree of set of circumstances. Did you just give someone legal advice? Or did you just answer that? I mean, it's not going to be easy. Not going to be easy. I think that's the reason why the footnote, Simone, where it says, the footnote says, the notary in Louisiana who is not licensed to practice law may not give legal advice per se. That's why I think that they kind of hedged even the footnote that is going to be tough.
Even though we're studying out of a notarial law book.
Even though you read it out of a notarial law book, yes, ma'am.
Have you ever known anyone to be prosecuted for UDL?
No, I have not. Mm-mm. Thank goodness. Yeah. All right.
Right.
Yes, Dan.
Oh, I've heard that term. I can't find it back.
What term is that?
Usufruct.
Usufruct. Yeah.
I don't know what that is.
You don't know what it is?
No.
We're gonna talk about it quite a bit, several chapters down the road. But this is the idea behind usufruct. We're a community property state. Usufruct is a mechanism of community property. Community property is this concept that once you're married in the state of Louisiana, that everything that you buy, whether it came out of your wallet or your wife's purse, everything that you buy belongs to the both of you. Okay? It's what's yours is hers, what's hers is yours. And so the idea is that when you pass away, your estate consists of half of everything that's in the community. Half the house, half the car, half the money in the bank, half the savings account, half the boat. If you've got children and you die without a will, then those children will otherwise inherit your stuff. Usufruct is what allows your wife to continue to use those things until she remarries. In the scenario we're talking about where you die without a will until she remarries. So usufruct is the use of community property upon the passing of a spouse. Okay? And look, for those of you who just said, "Ooh, that's a lot," we're going to come back to it. We're not close to being done with usufruct. Not even close. We're going to talk about it in a lot more detail.
Way more than that.
There's a lot more than that. We're going to come to it. But that's usufruct in big brushstrokes. Okay? It says he is also the legal advisor of the parties in that last paragraph on page 7, acting as a mediator who seeks to harmonize opposing interests while performing the role of a conveyancer. The notary does not act on behalf of either party. All right, so conveyancer. Kim, you were talking about that. Conveyancer. So in your capacity as a notary, will you guys be doing conveyances? Yes. Can attorneys do conveyances? Sure. Only if the attorney is a notary. Attorneys who are not notaries, and not all attorneys are notaries, attorneys who are not notaries cannot do conveyances.
And that is perplexing to me.
What's perplexing?
That an attorney is not a notary.
It's only because they haven't gone through and filled the paperwork
I
out.
was going to
That's
say,
it.
when you become an attorney, like the notary is like a firm.
Yes, that's a good way to put it. If you pass the bar, the notarial commission feels as though you're qualified to be a notary. All you got to do is fill out the paperwork. Why doesn't an attorney fill out the paperwork? The answer is because they don't want the liability associated with it. They don't want the liability associated with notarizing a document. They want to pick up the extra E&O coverage. They just don't want to be associated with it. I know a number of attorneys who chose not to be notaries simply to remove themselves from the potential consequences of being subpoenaed. Did you get Kim's driver's license when you met with her and had her sign her will that day? Were there 2 witnesses in the room? They just don't want to deal with it. So they just choose not to be notaries. A few. I said many. A few.
And depending on what area of law you practice in too.
Yeah, if you're going to be a trial attorney or a research attorney or something like that, you may not have a lot of need to notarize documents for folks. Okay, but yes, it's a perk. If you pass the bar, you're deemed to pass the notarial. All you got to do is fill out the paperwork and get it.
But if you lose your law license, you still can be a notary.
You can? I don't know.
No?
I don't know. I didn't think so. I'm not prepared to contradict you on that because I don't know the answer for sure. But I believe if I lose my law license, I lose my notarial commission too. I see a couple of heads shaking in the back like that's right. So maybe it's something we've already covered in a previous meeting. All right. So you will be a conveyancer. I think if anything, depending upon, maybe you choose to go into the automobile industry and that's what you're going to do, and you may not be passing the sale of lots of cars. But I think that you're in your capacity as a notary, executing donations and sales and partitions and things of that nature is probably one of the more common things that people will ask you to do. And so I think that the notary's role as a conveyancer is one of the more prevalent roles that a notary takes on. Okay? It says, it is for the vendor and purchaser who may or may not be represented by legal counsel to agree to the terms of the sale. So what they're saying is that the notary, it's not the notary's job to negotiate a real estate transaction. It's simply the notary's job to draft the documents that reflect the real estate transaction in terms of their capacity as a conveyor. It says it is for the vendor, that's the seller, and the purchaser who may or may not be represented by legal counsel to agree on the terms of the sale. It's their job to work out the deal. And they simply present the agreement to the notary drafts it, has them execute it, and then they notarize it, and now we have a conveyance. That's the course of action. Because the jurisdiction of the notary only extends to cases where the parties voluntarily seek his assistance, the notary cannot take sides where a dispute arises. There'll be times, I'll be at a real estate closing and the parties will start fighting. Doug, you ever seen that happen? They'll start fighting, and they'll immediately look to the notary to resolve the dispute. And that's a very difficult position for you to take, because the moment it looks like you're kind of leaning one way or the other, there may be some sort of perception that you're on their side or that you're representing them in that transaction. So it's very difficult for you to do that, but it's certainly a position you could easily find yourself in. All right, page 10. I actually don't have anything in the first three paragraphs I want to talk about. The fourth paragraph starts off with, the functions of the notary in the conveyancing process does not end with his advisory or drafting duties. His quasi-public role includes the duty to verify that state and local taxes arising from transactions have been paid. He cannot execute or pass an act conveying immovable or real property unless the payment of the pertinent taxes is evidenced by a certificate of the officer having charge of the collection of such taxes, and a fine is levied on the notary in case he fails to comply with this requirement. Notaries usually complain about having to perform an unremunerated public function which involves much responsibility due to the difficulty in interpreting certain fiscal laws and the possibility of arithmetical errors. Now at the bottom on page 7 there's a footnote. I think the footnote pertains to something a little bit higher up in this paragraph, but it says this should not be confused with the issuance of a title opinion, which in Louisiana is reserved for a licensed attorney. Alright, so let's talk about that paragraph where it says the function of the notary and the conveyance does not end with his advisory drafting duties. More often than not, you can disclaim responsibility for not performing all those functions. There may be some notarial jurisdictions where you have to verify taxes are paid, or you have to verify that there's no outstanding mortgages on the property. There may be some jurisdictions where you have to provide that service in your capacity as a conveyancer. But in this jurisdiction, in Louisiana jurisdiction, you can just disclaim liability for it. You can say, hey, I was asked to prepare this document in accordance with your instructions. I did not check taxes. I did not check the mortgage records. I did not check anything. I'm not rendering a title opinion to you. I'm simply drafting a document in accordance with your instructions, and you're going to let me off the hook for all the stuff that I'm not going to do in this transaction. And that's the vast, if someone's coming to you because they need a simple, quick claim deed because husband and wife are getting a divorce and the husband's got to come off title so the wife can refinance her house, or brother and sister just inherited a piece of property and brother wants sister to have his interest in the property, and they're not looking for you to do all kinds of title work. They just want you to draft the documents, notarize them, and get them filed in the public records. Well, then you can it's very easy for you at that point in time to say, well, if you just inherited it and you're on the hook for the taxes no matter what, why would you want me to check the taxes? Why would you want me to check mortgage records? Maybe the succession attorney did all that. So you just disclaim responsibility for it. Who collects taxes in St. Tammany Parish? Sheriff does. Who assesses taxes? Assessor. A lot of people call the assessor thinking that the assessor is actually collecting the bills. The assessor just determines what your taxes are. The sheriff collects them. So if you do have to verify if taxes are paid, you call the sheriff's office for that information. You don't bother the assessor with it. They'll quickly tell you that if you do bother them with it, though. All right. It says another.
Right.
Oh, I'm sorry, Lisa. What's your question?
When you do that disclaimer, which we do a lot, in the donation saying, we're not doing a title opinion, we're not doing that. Can you I've seen it done, and where you put in that you are not recording it, and it's on on them to record it?
Mhm.
That's legit?
Yeah.
Okay.
Any kind of disclaimer is legit as long as everyone acknowledges it. You can't bury it in the document and then have them initial something a page and a half later. You know, if you're going to put something in there that says I'm not responsible for recording it, then you want to have them initial
So even
that
though
particular
it's
paragraph.
supposed to be recorded, it can be on them to record it.
Well, I've got a little story about that. I got a client of mine that came in one time, and of course, what you're going to find is more than likely is that most of the people that come to you are not going to want to pay you for the services that you deserve to be paid for. And I've got a client of mine who's a very, very good client, but he's notoriously cheap, and he doesn't want to pay for anything. So I'm preparing a document for him to transfer a piece of property to a person that's been buying it on installments. It's called a bond for deed. We'll talk more about bond for deeds down the road, but essentially they're buying it on installments. He goes, well, Ray, what's it going to cost for me to get this document drafted, notarized, and recorded? And the answer was $300. Oh, $300, that's too much money. What would it cost you just to draft it, and I'll take care of recording it myself? I said, $150. So I draft the document, and they come by and they sign it, and I put a disclaimer in their lease that says, notary not responsible for the recordation of this document, and I had him initial it, and I handed it to him, and I took my $150, and that was the end of it. About a year and a half later, he calls me up and says, I just want you to know, I think you committed malpractice. I'm still getting the property tax bill on this particular piece of property, and it should be in the other person's name by now. And I don't know what kind of liens and judgments are out there and what kind of damages she's got for the homestead exemption she's not been eligible for. Ray, this is sloppy, man, sloppy. And so that's not what anybody wants to hear. So the first thing I did was I went and pulled the file, and I opened it up, and I looked at it, and it says, notary not responsible for the recordation of the document. So I call my client back, and I say, hey, by any chance, are you holding the original in your hand? He says, as a matter of fact, I am. And I said, okay, take a look at this paragraph. He goes, oh, all right, sorry, talk to you later, click. That was the end of that. So if you're not going to record it, because recording is absolutely your notarial function, if you're not going to record it, you've got to disclaim it. Because let's say I had fallen asleep at the wheel. Let's say I had not filed that document, and she wasn't eligible for homestead exemption, or more importantly, he had died or had a judgment levied against him or had something that affected the title of that property, in my capacity as a notary for not recording that document, I could be liable for all those damages. So, no, if you're not going to record, disclaim it.
Or wish he would have paid that $150.
Well, you know, yes, I would have, because I guarantee you, if the person that bought it was savvy enough to realize that by his failing to file it, that she lost out on about $1,200 of the homestead exemption, I would imagine she would have asked him to reimburse it. But I never heard anything else about it. He was a little embarrassed that he did that. He's never mentioned it ever
She
again.
just thought she was getting away with tax without paying.
No, there's still a tax bill.
I don't know who was paying it.
She was responsible for paying it.
But it must have been going to him, so she must have never been, oh.
Oh yeah, he gets the bill, he forwards it to her.
And she wasn't getting it, so she should have
No,
said, well,
she
man.
got it.
Oh,
She got the bill. But the year, at the point in time he's calling me, by this point the bill should be in her name.
Right.
And she should have gone and filed for her homestead exemption, and her taxes should be significantly less. So when that
Okay.
bill shows up and it's still in his name and the taxes are still real high, now he wants to say, I screwed up.
Okay.
Hey, why didn't you get this document recorded? Thank goodness. There's a disclaimer that says, it's because you were responsible for recording it. That's why I didn't get it recorded. All right, the notary, yes sir.
Where do you put that in your quitclaim, or do you, like, with all the other disclaimers, you add it in, like?
So what happens is
no
sometimes
certificates, no title work.
the no certificates is kind of right there above the signature lines, and then
Right.
I put the disclaimers in where they're appropriate. If a client provides me a legal description, does everybody know what a legal description is? All right, so a legal description is a description of a piece of immovable property. It might be lot, block, and square. It might be go 300 feet north and 200 feet this way. We're going to talk about legal descriptions in more detail later. But if someone provides me a legal description and I don't actually do any title work to verify it's accurate, I'm going to put a disclaimer right behind the legal description. The parties provide this legal description, notary not responsible for errors contained therein. Right. Now, why do I want to disclaim responsibility for that legal description? Because if it's a bad legal description, I don't want them to expect I'm going to correct it for free. Because there is an expectation in your capacity as a notary that if you create a document with an error in it, that you are going to fix that document for free. If you made the mistake. So if there's an error in the description and I didn't put the disclaimer, there will be a presumption that the error is mine. And that's the reason why the disclaimer for the description is right there. The disclaimer for the title opinion, real close to where there's no certificates being done. I want that as close.
I've never seen, I'm not recording this, I'm not the party recording this or something like that.
Yeah, absolutely.
Write it by the signature.
Right close to the signatures, and I might still have them initial it
Last
anyway.
Paragraph right before they.
Yeah.
Do you document, well, I mean, probably you do as an attorney, but do you document when you come across this type of scenario?
Well, fortunately, there's a
There's a
file. There's going to be a paper. We try to keep a file for everything. Now, you just walk in and you've got a passport application that you need notarized. I'm not going to have a file for that passport application.
Sure.
All right.
I'm talking about in this scenario where you need to insert a disclaimer into the document.
Mm-hmm. Well, I created a file. So when that client said, "Can you do this for me?" I generated a file. And so not only do I have a paper file that's a reflection of what I did for them, but I have a document saved in Word on my computer I've been in this business, I've been self-employed for 10 years now. I've got every document I've ever done for anyone in the last 10 years on my computer.
But you're a licensed attorney for us who are not. We don't have to keep the originals. We don't have to maintain that.
Well, if the disclaimer is in the document, in that situation, you need to keep a copy of that.
That's what I'm looking.
Because if you let the only original go, and you don't keep a paper copy, and you don't have a computer copy, at some point in time, is it going to be refutable on your part that you weren't responsible for that? If the original gets lost, and you don't have a copy of it, how do you ever say, "I was never responsible for recording"? So you may just have to make an assessment on a case-by-case basis as to what you keep and what you don't. Or you know what you do? Remember when I said that sometimes no is the answer? You say, "I'm not providing you this service. If I'm not going to record this document and provide the entire notarial function, well, let someone else do it." The only reason why I agreed to not record this document is because he was a good client.
Sure.
I wouldn't do it for just anybody that walked in off the street.
I was thinking about a thank you letter. Thank you for your business.
What's that?
Thank you for your business. As a reminder, this document contains a disclaimer.
Right.
This is a reminder to
Go record it? Yeah.
I didn't.
Multiple originals?
Typically, when we have that situation, we keep multiple originals.
Mm-hmm.
Just,
Yeah, I thought there was always
They
an
stay-
extra original somewhere. I think way back in my dad's days, we did 3 and kept 1 in the file.
Well, in this case, because you give it to the client and we've had them lose it. You
Uh-huh.
know, they're going to record it and it's gone, but so we keep multiple originals.
I'm not a fan of keeping multiple originals. I'm not a fan. I'm not suggesting it's a bad practice, but I'm not a fan of it. This is the reason why.
Wills, yes, I would think.
What's that?
Wills, I would think, yes.
No. That's the last document I want to keep multiple originals of. That's the last one.
Or an original. You don't?
No. No, that's not the way
Oh
I
my
practice. I'm not suggesting that an attorney who does that doesn't practice correctly. That's not, or a notary who does that doesn't practice correctly. I'll tell you why in a second. Brian, the reason we don't keep multiple originals of mortgages is because we don't want them both to get recorded. You
I
get,
meant more sales, but yeah, I mean, I guess I could see a mortgage, but
yeah. And I can't tell you how many times
donations.
we come behind title work and we've got the same mortgage recorded twice. There's only one promissory note. Getting that second mortgage canceled is difficult. The reason I don't keep original wills is because if you go home and you get mad at your husband and you don't want to leave him anything in your will, then you gotta live to Monday and come back to my office to get your will back and change it. So I like my clients to have complete custody of their wills, so they've got the discretion to change them on the spot by ripping them up if they choose. And I don't even like keeping a copy of your will, because if you do change your original, you got to let me know that you changed your original, because in theory that copy could be probated if you die without the original will, or you die with the original will and it can't be found. So I'm just not a fan of that practice. I'm not saying that all attorneys are a fan of it or all notaries are a fan of it. I'm not a fan of that practice.
I was a notary in Georgia for 7 years.
Okay.
And we kept them in the bank, at the bank.
Okay.
But it was a kind of crazy area of Georgia.
All right.
It wasn't crazy, no.
All right, so we're at the notary and the registry system. Is that where we're at, page 11? Right? All right, so title insurance as well as land registry systems were mainly devised for protection against title insecurity, and none of those systems is able to work without the intervention of a professional conveyancer. Now, what they're talking about, land registry system in St. Tammany Parish, they're talking about our clerk of court. She is our land registry system. Who's our clerk of court, by the way? Melissa Henry, newly elected, doing a great job. Website looks fantastic. And so she is the person who's responsible for taking all of our documentation and keeping it in a public record database that we can all look at. I want to move on. I want to move on to the next page. Page 13. It says the civil law in Louisiana systems of law. We don't need to talk about Islamic law, socialist law. I don't know that's ever been on the test, but let's talk about common law. All right, page 13, that last paragraph at the bottom, it says the appellation common law denotes a system of law that derives from the common law of England. This system forms the basis of the law used in most of the English-speaking world in every state in the United States except Louisiana. So, although considered English, this system was introduced into England with the Norman invasion of 1066 and was essentially continental in character. It's interesting to note that for hundreds of years of the Norman conquest, French was used in many English courts. Traces of this origin are evident in many common law terms such as, I can't pronounce that. All right, so common law, English common law. That's the guys with the white wigs and the black robes and that kind of stuff. You've all seen it on television, right? You've all seen that. They still practice like that. Does anybody know who Oscar Pistorius is? No? Yes?
Heard of the name.
Heard of the name? He's the South African Olympic runner that killed his girlfriend.
Oh, yeah.
He's got the blade legs.
Yeah.
All right. Well, they actually showed some footage from inside the courtroom, and the judge was wearing the wigs, still wearing the wigs. Okay, so that's what we're talking about. When we talk about common law. Now, when we talk about common law, there's a lot of things about common law that you would be amazed that we utilize, even though we're not supposed to. Like, who's ever used the word tenant, landlord, power of attorney, statute of limitations, squatter's rights? They're not going to find any of those words in the civil law. Prenuptial, thank you, Kim, prenuptial agreement. You're not going to find any of those words in the civil law books because they're not civil law terms. But we've used them so much and we've become accustomed to using those terms so much that we use them. As attorneys, we use words landlord and tenant. We generate leases that say landlord and tenant. But in reality, our law books say lessee, lessor. We don't say squatter's rights, we say acquisitive prescription. We don't say power of attorney, we say mandate, procuration. We don't say prenup, we say matrimonial agreement. So we have these same legal concepts, we just don't call them the same things, despite the fact that those terms are often used in its place. Because if I say prenup, I bet everybody in here knows exactly what I'm talking about. I say matrimonial contract, and you're wondering exactly what we're talking. You're not 100% sure. If I say procuration, hey, Michelle, you have a procuration? You have any idea what I'm talking about? Michelle, you have a power of attorney? Yes, I know exactly what you're talking about. So despite the fact that we don't have these terms in our books, we certainly appreciate those concepts. And we do have the concepts. We have all those concepts as well. All right? Civil law on page 14. The term civil law generally refers to the system of laws derived from Roman law. The most famous descendant of the Roman tradition is the Code Napoleon or the Code of France, enacted in 1804. The civil law tradition extends across almost all of Europe. Colonization and cultural ties led to the implementation of a civil law system in most of the South and Central America and much of Africa. That Central America is the reason why Guatemala and all those Latin American countries practice civil law. Okay? So we're a civil law state. Anybody ever heard the term, yeah, you guys in Louisiana, y'all have that Napoleonic Code. Right? That's where this is all stemming from. We don't really have the Napoleonic Code. I don't know if we're going to cover it in as much detail as we need to, but if you read this, it's going to say not a whole lot left over from Napoleon's days in our law books, but the fact that it's based in French law and French tradition, that much is uncontrovertible. All right, so here's the systems contrasted, civil law and common law. While the most apparent difference between the civil law and the common law lies in their origins, there are other subtler ones. Common law, judges are lawmakers. Who's ever heard the term case law before? Heard it on TV? Lisa's heard it. Case law, it's the idea that the outcome of a case has an impact on all of the successive cases. All right, theoretically, the role of a judge at common law is in part the role of a lawmaker. Judges in common law states, their decisions become law. Faced with situations, somebody has something to say?
It says
No?
one person making that.
One person, that's right. So it says, faced with situations for which there existed no positive law, English judges were often required to make decisions based on their perception of equity of the situation, partly due to the concept of precedent. A common law judge rendering a decision involving a new legal issue will establish a rule that, at least in part, controls future decisions. The actual weight to be accorded to the decision will be determined by the principles involved, the logic used, and the authority of the court rendering the decision. The term at law or in equity, you'll often see that in Louisiana contracts. there is a common law foundation for that because we don't really have ad equity in Louisiana. We don't really have that. Civil law judges are law interpreters. See the big difference? English judges make the law. Civil law judges interpret the law. In a civil law system, court decisions do not establish precedent, nor are they a source of law. In a pure civil law system, the legislature is viewed as the representative of the people and the primary lawmaking body. Consider Article 2 of the Louisiana Civil Code. Legislation is a solemn expression of legislative will. The confines within which judges are to operate are set out in parts 4, 9, and 13 to wit. We're not going to go through all those. So, if I am in a district court, the judge that's in that district court, they are responsible for interpreting the law. And they are also responsible for looking at how other district courts have interpreted that law, and they really shouldn't get too far out from that particular decision. But that happens. We've got the 22nd Judicial District Court in Covington. They've got the 34th Judicial District Court in St. Bernard Parish, the 24th Judicial District Court in Jefferson, and judges at these levels are all equal. And a judge in Jefferson might make a decision, and a judge in St. Bernard might make a decision, and a judge in St. Tammany might make a decision, all based upon their interpretation of the law, none of which are bound to rely upon the other's interpretation as the basis for it. So who's in here has ever heard of the term the Court of Appeal? So what happens is that when you've got districts that are split, when judges in different district courts have made decisions about the exact same set of facts because they've interpreted the law differently, ultimately someone's going to appeal that decision to a higher court. Now the moment that the appellate court makes a decision, every court within the appellate court's jurisdiction has to honor the decision of the higher judge. It's kind of like a little totem pole. So once it gets to the Louisiana State Supreme Court, every appellate court, because we've got multiple appellate court jurisdictions, every appellate court now has to honor the state Supreme Court's decision. Consequently, it trickles down and all district court judges have to honor that decision too. It's called unifying the districts. Splitting the districts is when they have different opinions. Unifying the districts is when you go up the ladder and have a higher judge make a decision that forces the lower judge to honor it. Yes, ma'am?
So it seems like when it gets to the appellate court, then it kind of starts acting like the common law.
No, they still have to interpret. They still have to interpret. They don't have the discretion to make the law. The only time that a civil law judge actually has an opportunity to make the law is if there is something before them that there is nothing, absolutely nothing out there for which they have a grounds for making a decision. That's the only time that they have an opportunity to make an equitable decision. And that's just a very, very rare set of circumstances.
Which one do you think is more fair? The common law, the way they do it? Or
I'm personally a fan of civil law.
Civil law, definitely.
Because I see why now.
Well, I'm not a common law attorney. I gotta be a fan of civil law.
I never really looked at it.
You want one opinion or?
No, I just never really looked at it. So in Louisiana, I can see how you can kind of name drop. I don't know. It just seems like you can kind of.
I personally, even if I wasn't a civil law attorney, I personally have an affinity for the concept. I have an affinity for the concept that judges are interpreters and not lawmakers. For the very reason I think what you're alluding to, Simone, is you're kind of saying that judges could use their authority inappropriately. There's going to be maybe a greater opportunity for corruption when they have that kind of discretion.
I see why it happens down there.
Right. So yeah, I'm a fan of civil law.
It's a little off, but like, you know how you said that certain, they based it off of other judges,
Mm-hmm.
Okay, like the situation that I would want to know about, the guy that, raped the girl and only got like 3 months or 6 months because the judge decided that.
In California?
Yeah, how did that, like what court, I know it wasn't in Louisiana, but what played that factor in that? Like how is it that the judge could be, that's like unheard of,
Yeah, I agree with you, but that's a criminal. That's a criminal issue. It's got neither nothing to do with civil, nothing to do with common. It's a criminal issue. And there are mandated minimum sentences for certain types of convictions. I can only imagine there was just no mandated minimum sentence for the particular crime that person was found guilty of. Because there are various degrees of rape and sexual assault and various degrees of all kinds of crimes. And they're going to be the more severe to the less severe. I can only imagine, and this is not the answer to your question because I don't know enough about it to answer it definitively, I can only imagine that they were actually convicted of one of the lesser offenses in which the judge had the discretion to set that sentence. So let me give you an example of what I mean by discretion. A good friend of mine, good client of mine, gets his second DUI in 10 years, or is it the third DUI in 10 years. Okay? You read the law, mandatory 6 months in jail. This is a hardworking man with a family who's made 3 very bad decisions over a 10-year period of time, who's got a job that if he can't show up to, he's going to lose. I mean, significant consequences to this decision. And we moved heaven and earth to try to get him out of jail for fear of him losing his job. I even managed to get an audience with the judge, who basically said, Ray, my hands are tied. If he's found guilty, and he will be found guilty, this is the mandatory minimum sentence he's going to get. There is nothing I can do. Even if I wanted to, there is nothing I can do. If you guys found guilty, he's going to jail. He was found guilty. He went to jail. And he was right. He was right. If you look at the law, it's clear. There's not discretion. There had to have been discretion in that set of circumstances. Okay? All right, the Louisiana Civil Code on page 15. It says all civil law systems generally maintain their laws in a set of codes. The codes, particularly civil codes, provide a comprehensive system of laws governing most private conduct between individuals, ranging from family matters to basic commercial transactions. Flip it over a page. I don't have anything in here that I made a comment on that I wanted to talk about tonight. Is there anything in here that you think that's relevant in this chapter, Mom? Besides what we've talked about, the difference between common law and civil law?
No, I would have passed this and through.
So as far as this chapter was concerned, the only thing that I felt of any relevance was the distinction between common law and civil law. I wanted you to have an appreciation for that, particularly because we're so close to Mississippi. We're so close to Mississippi. We do so many things with people from Mississippi that just 15 minutes up the road, whole different set of rules and laws, just 15 minutes up the road. So I wanted you to have an appreciation for that, but there was nothing else in chapter 2 I wanted to talk about.
Real quick, how did we become a civil?
It's actually quite interesting. It has to do with the Louisiana Purchase and an effort that was made by French attorneys in the greater metropolitan area of New Orleans who did not want to change the law that they had practiced. So there was a lobbying, an effort to lobby to keep Louisiana French-based law because we were dominated by French-based attorneys at the time. That is a big brushstroke answer to your question. There's a lot of my business.
Claiborne and an attorney in New York or something, huh?
Livingston.
Livingston? Well, you know the answer.
No.
My business partner is a history buff. And if he was up here, he would bend your ear for the next hour and a half about why we're still civil law. My big picture answer is that we had too many important people in New Orleans who did not want to convert from the law that they had been practicing to a new law of the rest of the country, and they were powerful enough people to keep it that way. Yes, sir.
Going back a few minutes ago on the test and the passing rate of North Louisiana, South Louisiana, South Louisiana being greater, my conjecture would be maybe that South Louisiana is a little bit more of the French heritage, French down yonder here, versus the North, and maybe that has a little bit more acceptance of the civil.
Certainly could. I think that what we have is we have more suburbanized areas. We have I'm going to say better education opportunities.
More rural. Poor parents,
right.
Poor bad test scores they compared it to,
right.
She gave us a lot of reasons why it was like this.
And they struggle because they don't produce notaries up there, and the people in the automobile industry.
That has changed a lot.
Yeah, what's that?
That has changed considerably in the last 10 years.
It's still a
It is an issue.
It's still an issue.
But when they created Delta Community College, they started a course there, and a lot of people go to that community college. I mean, it is.
I'm not suggesting that there's not education opportunities. It just seems that the passage rate is lower up there, and there was a lobby. I mean, I would imagine it's still going on. But Tom Benson, the owner of the Saints, who's in the car business, is actually one of the largest proponents of this idea that we should create a notarial system inside Louisiana of people who just verify IDs. Something very common to what the common law notaries are doing, because there's not enough notaries in northern Louisiana to fill the job needs. There's not enough notaries up there to work in car dealerships and auto title places and real estate title places. So let's just create this notary who pays a fee and become a notary, but all they can do is verify your ID. What's the issue with that? What's the issue?
Other things.
Okay, well that is the issue. The issue is that us as a consumer don't know the difference between a notary who can only verify your ID and a notary who can actually do your last will and testament, or do a small succession for you, or prepare your cash sale.
Call it something else, I don't know.
And so as a result, the fight or the pushback against this concept of letting people become notaries by default, the pushback is that we're going to be producing an unequal level of notaries, and the consumer is going to be penalized because they won't know if the notary that they're dealing with can actually help them with what they're asking for or not. And we can't count on the notaries to police themselves. That's the pushback.
Wouldn't some of those notaries qualify for the 40,000 population of under 40,000?
You still have to pass a portion of the test to do that.
That's correct.
Oh,
You don't get to be a notary just because you live in a rural area. You still got to pass at least a portion of the exam.
So now it's the whole thing.
But now the
Now it's
test
the
is
whole
not
thing.
portion.
Well,
How about they change it?
that's a great point. So let me tell you what we're talking about. There was a rural exception to the notarial qualification, and if you were in a rural area and you passed a portion of the exam, you could still qualify to be a notary as long as you passed 2/3 of the exam and you lived in a parish that had a population of less than 40,000. But as my dad just pointed out, there's no longer 3 parts to the exam, so you can't pass a portion of it like you could. But to my knowledge, that's probably still in the book. It's just not practical because you can't pass a portion of the exam anymore.
That was an easy fix.
Yep, just take it out. All
They
right.
would do it anyway, because we had a student that passed 2/3 of the test, and she couldn't get them to commission her.
Yeah, the commission still has the discretion. It's not an automatic.
I was gonna say, you
Right.
know, if you pass, like, you know how you said once you pass the test, that's it, but doesn't like the governor and, the commission have to sign off on it?
They do, but they do. We were talking about that. The governor has the discretion to put a moratorium on the issuance of notarial commissions, but never in my knowledge has the governor ever done that. So if you pass the test, getting the signature is really more or less just procedure. It's not something that you actually have to worry about them approving or not approving. Okay? All right, so page 19. Did we just cover that? Chapter 3?
Oh, I'm on 25.
Did we do chapter 3 at all?
No.
You're
All right, change, all right, chapter 3, page 19. Second paragraph says, under Roman law, the notary was essentially a public secretary or scribe. Anybody ever heard the term scrivener's error or scrivener's correction? That's a common law concept, and it's kind of stemming from the idea that a notary didn't prepare something correctly, and it's because they're referred to as scribes, or a public secretary as a scribe is a common law concept. The office of notary under the common law appears to have its origin in Roman concept, but during the formative years of the common law, it became associated with the church. As the common law developed, the powers that a notary might otherwise have were, to a greater or lesser extent, usurped by other members of the developing legal community. So what they're saying is that the reason why notaries in common law jurisdictions don't have the stroke that we have in our civil law jurisdiction is because the roles of other legal authorities in those states have kind of replaced their job function. Middle of that page, broad powers in Louisiana. In Louisiana, the notary is given broad and far-reaching powers to draft and execute many types of instruments having legal effect. Notaries in Louisiana are authorized to make inventories. What's that? How do you make an inventory? Go ahead,
I'm
Brian.
not sure how you make it, but with a succession would be like you go in the house and say he's got,
I told you that dude was smart. Yeah, that's exactly right. So making inventory. Now look, what they're talking about is like old school notary making an inventory, just like you were talking about.
Which you really don't see that too much. You see some of it in succession, but you don't get that specific that much.
Right. So person passes
It has to
away.
be big items.
Right. Person passes away. There's 5 kids, and 5 kids don't get along. So somebody's going to make an inventory of what the decedent had so they know what they can split up. So they hire the notary to go in there and do that work. And that notary goes in there and makes an inventory. And they go in there and they just kind of start documenting it. And you're 100% correct. We don't see it much anymore because there are cheaper ways to handle it now. But I've looked at some old successions recently, and you can see that when the notaries were going in, I mean, they were itemizing everything. I mean, how many knives and forks and spoons were in the drawers and that kind of stuff. Yeah. Well, I'd imagine they were getting paid by the hour, so they're probably taking their time.
Maybe paid by the item.
Or maybe getting paid by the item.
Also, you know,
Sounds
just
like
the situation with the whoever the heirs were, it probably paid to inventory every
Mm-hmm.
item.
Yep.
You know, I learned from a long time ago that pretty much there's some truth comes out in an estate matter when there's money at stake.
Oh,
you see,
yeah.
you see.
People's true colors come out.
Oh, yeah.
I didn't want to say it, but yeah.
Hang on one second, we'll come back to you guys. What was your question, Kim?
No, it's, what's happening a lot, I've noticed with like, is the parents are giving away the stuff before. I know that's too late and it has really nothing to do with it, but my advice, yeah, and the parents get old, you know, the
Not the last
jewelry,
3 years.
my grandmother, we already know, you know, who's gonna get what and who's,
Okay.
or they give it to us already. You know.
Lisa, you had a question?
But that's,
I don't
nothing
see
to
this
do
like
with
as
this.
one of the powers, but I know there's an article that says if an original will can't be found, a judge can appoint a notary to go in and search
Mm-hmm.
for a will.
Yeah.
Is that,
I would imagine there's going to be a phrase, it's not in this particular paragraph, we're going to talk about how notaries have the right to make inventories and raise the same. And the phrase raise the same, it alludes to what you're talking about. And when we come across that phrase, we'll emphasize it. But I'll tell you what, I'll tell you right now, raising the same is that a notary's job was to seal the house. And then they would actually take like police tape, seal the house, and then they would put their seal on the tape. And that was raising the same. And the idea was everything inside the house was now underneath your jurisdiction. And if that meant finding a will, or the case may be, then that was the appropriate course of action. Simone, you got a question?
Yeah, just so if someone calls you, I know they probably don't, like you said, no longer do it, but to make an inventory, does it have that restriction on the, like 75,000 and under for opening the succession? Because you're not really opening it, you just.
Well, in the context of you making an inventory, it doesn't make a difference what size the succession is. But let me tell you guys what Simone is alluding to. In your capacity as a notary, you're going to be able to do successions for folks. But there are going to be qualifications, there are going to be criteria upon which you can do those successions. And I don't want to say 70, is it 75, Dad, or 100? 75. And so $75,000 is the cap. That's the cap value of an estate for which you can do a small succession. And so if the cap value of the estate is $75,000 or less, Simone, they might come to you and ask you to handle the succession. But the cap value of the estate is $300,000. They might still come to you and ask you for your assistance in your capacity as a notary to do an inventory. So your role in the notary to do an inventory is not capped by a dollar amount. It's just based upon that involvement. Let me tell you the reason we don't do it much anymore is that there's attorneys have essentially taken that job. So the attorneys have the ability to file what's called a sworn detailed descriptive list of assets, and they essentially get the person who's been appointed the executor of the estate to go do the inventory on their own, under the pretense that this is just the most efficient way to handle it. And if the executor has had to has had to post a bond of some kind to ensure that they're going to provide this service in a fiduciarily proper capacity for all the other heirs, well, then what am I going to pay a notary to go in there and do an inventory for? I got an executor, been approved by the court, got a fiduciary bond to do a good job, and the attorney says that I can go in there and make the inventory myself, and they'll just put it all in the succession. And so it saves time and it saves money, and that's the reason you don't see notaries providing that service.
But they still do though. But
Still can.
Attorney, still can.
Oh yeah, no.
What's it called? A sworn?
Sworn, detailed, descriptive list of assets. Okay. There's a couple of things you can call it, but that's essentially its name. You guys are going to be able to appraise stuff. There is this idea that you should have, because you are a conveyancer, because you are in the business of passing conveyances, that you should have a better idea of what things are worth than anyone else. Does that mean, Michelle, that you're going to go into the appraisal business? No. Because appraisers in the state of Louisiana have to be licensed. So where they're talking about you being an appraiser is maybe where a judge wants your opinion of value and a judge orders you to render that opinion. Or maybe in the context of an inventory, you render an opinion upon value. But you're not going to become a notary and then go into the real estate appraisal business. There's not a correlation there. It's appraising in the context of a judicial proceeding. More often than not, a judge is going to want a state licensed appraiser to appraise the property. They're not going to, although you have the right and the discretion, the authority in your capacity as a notary, it's not something a judge is going to want to impose upon you. You know why? You're not insured for liability associated with that kind of work, but state licensed appraisers are. So it just makes more sense to farm that work out. What's that?
I got confused with one of your first questions with Mark.
Marketability of title?
Right.
Yeah.
When you said, you know, if we had the right to say how much something is, that's why I'm like, we're gonna be appraisers, so that's why I got, and now I get it.
All right. Partitions. What's a partition? Is that the thing you put in your bedroom so you have, no?
It's something when you change a document.
It's when you give
divide
property
it.
to different people, break up the property.
Oh.
Break up the property.
Oh.
So you're going to have partitions amongst husbands and wives. They're called community property partitions. When husbands and wives get divorced, they got to split their stuff. That's typically done in a community property partition. But you could easily do partitions amongst yourselves. I inherit a piece of property with my two brothers, and the three of us don't get along well enough to co-own anything. So we partition the property amongst ourselves. We each take 1/3 of what we've inherited. So partitions are a division of property amongst co-owners, and you can be co-owners in a variety of different ways. Well, we all know what wills are. Protests are essentially affidavits acknowledging that some negotiable instrument wasn't honored. We don't typically do protests anymore. Matrimonial contracts, also called prenups. You'll do quite a bit of that. Matrimonial contracts are pretty popular.
What about this? Is that post-nup included?
We don't have a post-nup. Post-nups are only done judicially.
It'd be a divorce contract.
Well, no, it doesn't have to be. Doesn't have to be. So the question is, marriage contracts are prenups. All right, that's the common law term. You won't be doing a post-nup.
But are there post-nuptial agreements in Louisiana?
Judicially ordered.
So, a husband and a wife, like say, the husband got caught cheating, she can't force him, or just tell him, you sign a post-nuptial agreement, that this doesn't happen again? She can't do that?
Oh, we're not talking about morality. We're talking about property.
I'm talking about property.
Okay. How is his cheating a second time? I'm not following you. I'm not following you.
That there are certain.
If you cheat again, I get all the stuff?
Yes.
That's the consequence? No. No, I would admit.
No, gosh, I've been gone from there for years.
No. I think that we have a constitutional right to due process, and typically we don't allow ourselves to give away things as penalties for inaction or action.
Right.
So I really am not in a position to say that it can't exist legally. I just don't think it can exist legally. I don't think you can have an agreement that says if you cheat on me, I get all your stuff.
Well, that's
Ooh, Lisa.
That's what it comes down to. But that wouldn't be the language.
Right. So Lisa just talked about covenant marriage. That's way down the low. We're going to talk about covenant marriages. We're not going to talk about them a lot.
Isn't that part of it? There's something kind of in there.
It just makes it really hard.
So what happens is this. We have an opportunity before we get married to opt out of Louisiana's community property regime. Dan, you remember when I said that this idea that what's yours is your wife's and what's your wife's is your wife's? You remember when I said that?
Yes.
You didn't hear me say that? All right. So it's what's yours is your wife's and what your wife's is yours. That idea of community property, we have an opportunity before we get married to opt out of that concept. We don't have to go into community property. We can stay separate in property. You typically see that when one person is bringing a little bit more to the table when they get married than the other person. Okay? Either a little bit more income or a little bit more assets, and they just don't want to get those things commingled and lost. That's a prenup. That's a marriage contract. Now, if after we get married and I get into an automobile accident and I'm grossly underinsured, and I'm concerned that I'm going to get my pantsuit off, I might try to then say, well, everything belongs to my wife and I've got nothing, so that if I get sued and lose, they've got nothing to take from me. Well, the law says no. Once you get married, the only way you can get your stuff divided and come out of community property is to come before a judge and show a judge why you're doing it. And if the judge sniffs that you're doing it to avoid creditor attachment, then he or she's going to deny it.
Sure.
So postnuptial is done by judicial order. Prenup can be done by a notary. And you may, I said you wouldn't be involved in a postnup, and that's not entirely true. An attorney may not want to draft the agreement and may tell you to go see a notary to draft the postnuptial agreement, but more often than not, because you have to have an attorney to file pleadings for a termination of community property after you're married, more often than not, they draft the postnuptial agreement, or the marriage contract at that point. There is one exception to the rule I just gave you, one exception, and we'll talk about it more when we actually get to that chapter. If you move here from out of state, married, you have a window in which you can file your marriage contract. Is the window a year? I think the window's a year. We'll actually cover it. But if you move here from Mississippi and you are separate in property in Mississippi and you're here, as long as within the year you file your marriage contract, the law will let you file your marriage contract after you're married on the condition you've moved here from out of state and you've done it within that window. I think that window's a year. That's the only exception to marriage contracts post-marriage that don't require a judge or an attorney. Okay? All right. Conveyances and generally other contracts instrumented in writing. A Louisiana notary is also empowered to execute authentic acts, receive acknowledgments of acts under private signature, and officiate at family and creditors meetings. What's a creditors meeting?
Bankruptcy.
Bankruptcy. Do you think you're going to be doing that in your capacity as a notary? No.
That's legal stuff.
Well, it's federal law.
Yeah.
Bankruptcy is done underneath a federal law, and bankruptcy courts appoint a trustee to oversee the creditors meeting. So there's not really a role for a notary. Now, there may have been a time when bankruptcy was governed by state law, and maybe a notary served as a trustee in those meetings, if that were in fact the case. But I've been practicing law. I was a banker before I was an attorney, so I've been in and around this industry for at least 30 years now, and for 30 years, bankruptcy's always been federal. And there's always been a bankruptcy trustee appointed by the bankruptcy court. Family meetings, again, that's what social services does. There was a time before social services where maybe a notary was brought into a judicial proceeding to make a determination about what was in the best interest of a child. And there's now special privacy groups like CASA, right? There's special privacy groups like CASA that do it. There's social services that do that. So the notary's job to serve in a family function has kind of been usurped by governmental procedures. Okay? And that's it. That's all I had for Chapter 3. Chapter 4, Louisiana court system. Turn to page 24. These are different types of courts. These are different types of courts we're going to find in Louisiana. Justice of the Peace Courts. Justice of the Peace Courts handle minor money disputes up to $5,000, may issue some arrest warrants, set bail obligations, hold preliminary hearings in some types of minor criminal cases. Though customarily addressed as judge, justice of the peace are magistrates, not judges. Tracy Powell was the justice of the peace that was around the corner from my house. Every time I see Tracy, I call her Your Honor, I call her Judge. Technically, she's not a judge. She never stopped you from calling her that, but that's not the appropriate term for it. So if I've got a $5,500 dispute, Michelle, you and I, we have a dispute, $5,500. Can I go to Justice of the Peace Court?
Sure.
Everybody agree with Michelle on that?
I think you can.
I can? Under what circumstances? $5,500. Book says $5,000.
It's over 5,000.
It's over $5,000.
I didn't see that.
But you can go and just sue for the $5,000 and let the rest of it go.
That's exactly right. So the answer is I don't have to sue you for $5,500. If we have a $5,500 dispute, I can just say I'm suing you for $5,000 and go to Justice of the Peace Court, and it will be much cheaper for me to sue you in Justice of the Peace Court because it's going to cost me a lot more money to sue you someplace else. So a lot of times people will actually reduce the cause of action, is what it's called. They'll reduce the cause of action to get into a lower court because procedurally or just from a processing fee standpoint, it makes more sense to get in front of a justice of the peace than it does to try to get in front of a city court judge or a district court judge. And so you'll see that quite a bit.
What's the criteria?
What's that?
What's the criteria?
Got to be elected.
Okay.
Yeah, justice of the peaces are elected. They're not necessarily legal professionals.
No.
A lot of
You don't have to be licensed.
she's gonna. What's that?
You don't have to be licensed attorney.
You're gonna be an attorney. You haven't got to be a notary. No, you just have
You're
to
not
be
a
popular.
notary if you're
Just popular, they never would. That's it.
And
Love
we-
Louisiana.
Yes. I'm not going to tell it tonight, but one of my favorite stories is a case that I had in the Justice of the Peace Court where we met in his garage and he didn't have enough chairs for everybody. I had to sit on his riding lawnmower to wait for my turn. And because Justice of the Peace, they're not obligated to have a courtroom. They're not obligated to have they're not obligated to have an office. They just have to be elected. That's it.
That is so country, but the one for us too, it is garage. I keep it on.
Lacombe?
Baranger.
Oh, LaRanger. Yeah, I was in Lacombe at the Justice of the Peace's house in Lacombe. It is. All right, so mayor's courts. Mayor's courts handle minor traffic matters and petty ordinance. Mayor's courts cannot legally exist within the jurisdictional limits of a city court. So do we have a mayor's court in Slidell?
no.
No, because we have a city court in Slidell. We have a very nice city court. But they do have a mayor's court in Mandeville. So you can't have city court and mayor's court. You can have one or the other. In St. Tammany Parish, we have mayor's courts, but we do not have mayor's courts in Slidell. Okay? City courts, parish courts. City courts are trial courts of limited jurisdiction. The general rule is that a city court has $15,000 or $20,000 civil jurisdiction, misdemeanor criminal jurisdiction, and full juvenile jurisdiction if there's no juvenile court in the parish. City court judges must be lawyers. City courts are local to municipality, and only one such court will exist in the municipality. I can speak for a little bit about Slidell City Court. I practiced there myself. Their jurisdictional limit is $50,000.
Yeah.
Yeah, you can go in there for more than $20,000. Judge Lambs has a pretty extensive. We got some bad kids in Slidell. I've never been in there that there wasn't at least a dozen kids in juvenile court in his courtroom. So yeah, city courts, district courts. That's the big place in Covington. Okay, that's the 22nd JDC that we have in St. Tammany Parish. Big, beautiful building in Covington. State district courts are trial courts of general jurisdiction handling both criminal and civil matters. 40 judicial district courts cover 63 parishes. The 22nd JDC is St. Tammany and Washington. What's that?
The 22nd, I was trying to think of the number there.
The 22nd. There's the Louisiana Supreme Court. On the next page, courts of appellate jurisdiction, courts of appeal. Go to that next page. So there's 5 circuit courts of appeal. Which one's St. Tammany in? Who can tell me? Thanks, Jackson.
That's the first one, Florida parishes.
There you go, Simone.
Yeah,
That's exactly right. We fall into the Florida parishes. We're in the First Circuit. But check this out. Right here in the Greater Metropolitan Area of New Orleans, we've actually got 3 different appellate courts that could have an impact on a decision that has something going on here, because St. Tammany is in the 1st, St. Bernard is in the 4th, and Jefferson is in the 5th. So right here in the Greater Metropolitan Area, we've got 3 different appellate courts having jurisdiction. That's the reason why we'll often see appellate court splits right here in the Greater Metropolitan Area, and you've got to get something to go all the way up to the state Supreme Court level to have any impact on the appellate court level. So if it doesn't get to the state Supreme Court, you could have decisions in Jefferson not consistent with decisions in St. Bernard, not consistent with decisions in St. Tammany. These judges aren't making the law. Their interpretations are not consistent with one another. That's all. Chapter 4. Chapter 4, I've got this highlighted. The paragraph on page 27. This is the paragraph right above legislation. I think this is kind of important stuff. What's that? Chapter 5, page 27, the paragraph above legislation. The sources of law are legislation and custom. Legislation is the solemn expression of legislative will. Civil Code Article 2, custom results from the practice repeated for a long time and generally accepted as having acquired the force of law. Custom may not abrogate legislation. Civil Code Article 3, when no rule for a particular situation can be derived either from legislation or custom, the court is bound to proceed according to equity. That's what we were saying earlier. Rarely, if ever, do they get to number 3. More often than not, it's addressed in 1 and 2. To decide equitably, resort is made to justice, reason, and prevailing usage. All right, the next thing if you flip it over, they talk about how a civil law state is regulated by a civil code. And then they talk about the civil code on page 28, and then they talk about the various books that you will see in the civil code on page 29. Book 1 is issues involving persons. Book 2, things of different modification of ownership. Book 3, different modes of acquiring the ownership of things. Book 4, conflicts of laws, revised statutes. And we're not going to cover all this stuff. Y'all can read that. It's all very straightforward. Page 32, jurisprudence. Who's ever heard that term before, jurisprudence?
Study of law. Yeah.
Jurisprudence is not really law. Louisiana jurisprudence is not really law. It is the legal authority that helps the notary to understand how a court has interpreted legislation or the sources of law. Under our civil law systems, decisions of the court are, legally speaking, not law per se, but only persuasive interpretation of the law. Remember how we talked about civil law judges don't make the law, they interpret the law? So jurisprudence is, you might say, well, jurisprudence would indicate, based upon previous rulings of the court, that this is how this particular situation is going to work itself out. Based upon the facts that you've given me, jurisprudence would indicate you'll prevail in this matter. So it's how historical court interpretations or historical court decisions have an impact on a set of facts in front of you. That's what they're talking about when they say jurisprudence. Page 33. I think this is kind of important. They give you all the abbreviations for everything else that we're going to read for the balance of the book. It would not hurt you to become familiar, like on where it says Louisiana Civil Code Article 1833, know that CC is Civil Code. RS is Revised Statute. Next page, CCP, Code of Civil Procedure. CHC, Children's Code. It wouldn't hurt you to become familiar with those abbreviations, even though it's not likely you'll be asked a specific question on it, because you're going to see those abbreviations throughout the book, and it would be helpful to know, oh, I know what that is. All right, Chapter 6, there's too much in Chapter 6 to squeeze in the last couple of minutes. There's a couple of things about Chapter 6 I want to talk about. There's a concept in here called the Public Records Doctrine that requires a little bit more than what I can get to tonight. So what's going to happen is on Tuesday, we're going to finish Chapter 6.
Yeah.
And we're going to roll into Chapter 7 as soon as it's done. And I think we've got Tuesday and Thursday allocated to Chapter 7.
You can do that.
Yeah. So I'll get Chapter 6 and Chapter 7 done next Tuesday and Thursday. So we got just 1 or 2 minutes. Any questions about what we covered tonight? Lisa, you had a question? Brian, you had a question, buddy?
The executor and executrix, back to the succession.
Yeah.
They're under oath by signing their little, that thing, like.
Yeah. No, so what's the difference? For those, hey, did y'all hear Brian's question? He said executors and executrixes have to sign oaths in conjunction with their role. So does everybody know what an executor is and executrix is? What's the difference between the two?
Man,
Oh, that's awesome. Yeah, so executrix is the feminine, executor is the male, and you can't serve in your capacity as an administrator and executor nothing without signing an oath that you're going to perform your duties in the best interest of the succession. So an oath is part of it. As a matter of fact, typically what happens in the succession is you're kind of issued an authorization. It's generally called letters. You're issued letters, which are kind of like your authorization to act in that capacity. You can't get your letters unless the oath is attached.
Testamentary, that's what they call it.
Letters of independent administration, letters testamentary, letters of independent executive. There's different levels of letters that you get depending upon the kind of authority that you have in that succession. But you're not getting anything. You're not getting anything without signing an oath. Yes, sir, Dan.
A question for Pam.
Okay.
What you've been flipping through, is that all on this flash drive?
That's the handouts. You don't have the PowerPoint itself, but it's the same thing,
Okay.
but it's on hand in the handouts.
The handout, is that what you email us?
No, that's what's the
That's what's on the flash drive.
Somewhere, okay, all right.
Yeah.
Any other questions?
I did, oh, sorry.
Oh.
As, when you act as, in a succession, the bond you post, is it determined upon the,
Size of the estate.
thank you.
Yeah. Yeah, if your estate's $5,000, the judge is going to make you go out and get a $50,000 bond. So typically it's going to be commensurate with the amount of assets you're going to be. All right, so after one good night, who's going to win the $500? All right, I like it. All right, guys, you'll have a great weekend, and I'll see you on Tuesday.
Right. This is a new book.
Straight to back.
Right.
All right.
It's a matter of fact.
Let me clarify.